Initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperation.
Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Nauman Riad.
Dr. Nauman Riad, the founder and convener of the Global South Network. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas.
I would like to point out that Dr. Riad's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings?
The influence of global judicial dialogue, where courts refer to decisions from other jurisdictions, is increasing. How does the Curia of Hungary navigate this global cross-fertilization of ideas, particularly between common law and civil law system, without compromising its national legal identity or constitutional integrity?
I don't think that there is a race between these influences, because this question of precedents is formally only a practice. Of course, it's an identity question for the UK, American, and the other common law countries. But for us, the continental non-precedent system is not so important. So we cannot say that we are not a precedent court. It's a question of legal identity, national identity. So the identity questions are, I think, much more deeply rooted in substantive law, in some specialties of the substantive law. For instance, in private law, we have some legal solutions which go back to the 14th, 15th century. But of course, these are always going closer and closer to the practice of other jurisdictions. So I don't want to mention the best practice ideas, but if we follow, of course, our law and our identity, in some situations we will find that in a small part, the other jurisdiction solves the questions in a much more simple way. And we don't lose our identity if we gather other practices, if we include some other interpretations. Why? Because identity is not a static question. Our legal or constitutional identity was not the same in the 15th century or the 14th century or the 16th when Hungary was occupied by Turkish troops for 150 years. That time the identity questions, of course, was different than in the 18th century, when everything was restored, when the Curia was set up as a permanent court, when we got this planum tabulare I mentioned. Not the same as in the 19th century, after the Napoleonic reform, which of course was important for the continent, the judicial reform, the institutional reform, the procedural reform, and it was not the same than in the 20th century, it's not the same. So constitutional independence is always amended, like a constitution. So not only the constitution, but the whole constitutional identity is always amended. There are always impacts, influences, and what fits with our thinking, then it's included. This is why I'm convinced that this cooperation, this judicial cooperation, the judicial dialogue is very, very helpful. For instance, at the Curia, we have a research institute in which we try to gather mostly the younger colleagues from the university to help us. Because for the universities, for younger academicians, it's important to have access to legal thinking of the courts. And for us, it's important to know what happens in the world. And who knows better than the universities? Because the universities have time, the academic staff have time to visit a lot of conferences. And they are very, very accustomed with reading different solutions, different interpretations, different texts, and to try to compare and try to summarize them. And we got it in this way. So they are formally also our employees, but their first employer are the universities, and they help us in researches which are important for us. For instance, we have a permanent research. I think this year we have the third turn or third section of it about judicial independence. Firstly, we look back to the former centuries. Secondly, we try to understand the theoretical character of judicial independence, and now we arrive to the comparative stage. And of course, there are some other important questions. For instance, now, of course, artificial intelligence. How can artificial intelligence involve to our constitutional and, if I may say, judicial identity? It's important, I think, for the whole world. In this question, we all are a village. And we are going to and then what is important is in this village, there is no difference between common law and continental law and other law systems, because we use the same computer, we use the same teams, and so on.
Thank you very much. I completely agree with you. Many of the points were very interesting. First, the constitutional identity is an evolving concept, and I think many of us overlook this phenomena, the evolving nature of the constitutional identity. and the engagement between courts and universities, which is very much, I'm sure it would be of huge interest to people who are watching and attending this session.